as judicial reviews are an established way in which you can hold the government to account when they act unlawfully. Bringing judicial reviews is sadly expensive, it's quite a complex operation, and there's a high bar to actually coming out on the other side with a success. But as everybody knows, I think we brought 2 judicial reviews, and the first one was the compensation case, which was heard back in December, and we did, in fact, win that, where we won it completely in the sense that the decision was found to be unlawful, and very importantly, the actual decision itself was quashed, which means it's completely set aside, and so one has to go back again and start again on it. Now, as far as the environmental case was concerned, which was our second main case, that was taken at December at the same time. We lost it, and however, on that day, the day we heard we lost, we also won leave to appeal it, which was actually encouraging because it meant the judge felt that there were grounds for the appeal. And as we all know, it was heard a couple of weeks ago, and we now await the result. I just mentioned up there, they are expensive, and I would also like to thank everybody in this room because we did raise the money, and I know a very large chunk and substantial proportion came from Wendover, which was excellent. Thank you. So, what is this environmental case? Well, it concerns the government's failure to do an assessment under the strategic environmental regulations. Now, these regulations and the fact that you have to do an SEA is as a result of European law and the provisions of something called Aarhus. And that's an international treaty designed to protect the environment, specifically to protect the environment, and the UK is a signatory to that treaty. So these regs are aimed at ensuring that the environmental considerations of whatever you're going to do are considered early. They're considered right at the beginning before you decide what actual proposal you're going to go with. And they require a full consideration of those alternatives, and the environmental aspects of them have to be consulted on. Now, the government say that the SEA directive doesn't apply to HS2. We disagree, and what the case is going to turn on is how this 2012 decision that Justine Green made in January 2012, how that is interpreted. So, what did we have when we got there? Well, there were 3 judges of the Court of Appeal. We had the Master of the Rolls, Judge Lord Dyson. We had Sullivan and we had Richards. Now, Sullivan is the rail man, and Richards was the European man. So that was excellent because we had somebody who was sort of into rail, and in actual fact he's really into rail. He has a modern rail, he has a little model railway in his garden. And he also drives a steam train for fun. Richards was pretty poker-faced throughout, but he asked quite a lot of questions in relation to the European aspects, as one might expect. The HS2AA team was S.J. Burwins, who were the solicitors, and then we had David Elvin, QC from Landmark Chambers, along with a junior counsel, Charlie Banner, also from the same chambers. And on the government side, yes, they came from the same chambers too, Landmark Chambers, and it was the same Tim Mould who ran the case previously. As we've said, in 6 weeks we were able to raise the required 100,000 in order to proceed. However, at the last moment, we did in fact wonder whether we were ever going to get there, because we had a protective costs order the first time round. And that means you have to pay all your own costs, but if you lose, you have to pay the other side's costs too. Now, we got a protective costs order the first time round for £10,000, which was a pretty good arrangement. and you're entitled to these things in an environmental context for a group like us. But the government refused to give it to us for the appeal. And in the end, we were forced to go to court 2 days before it started, fingers crossed to see how the court would view it, and the court gave us everything we asked for. They actually said we could roll over our previous protected costs order. So it was a good start, we felt. The timetable, as I'm sure people know, January 2012, that was the decision, and I put decision in quotes there, that was the decision that we all thought was a decision and a decision to proceed. However, as we learn in the case, the government said it was just a mere policy, and actually the decision still has to come, because the decision is at the hybrid bill stage. So, what was our case? Well, our case is, we say that HS2 is a plan or programme, and that this January 2012 decision sets out the whole framework, and it is also required by some administrative decisions. We say that that 2012 decision actually does influence Parliament, because the people are whipped, that have to vote, there's a paving bill, and there's a whole range of things that it's unreasonable to say that Parliament actually can take a different decision to what the government is putting to them, so to what the proposal they're being put to. The government, however, say that the January 2012 decision is not caught by the SE regs. They can escape them. Because they say HS2 is just a policy, it's just a philosophy. Parliament are wholly free to make up their own mind and do as they wish at the hybrid bill stage. And they could reject HS2 if they want to. The interesting bit that happened in court on those days was that government astonished the three judges, and they used that phrase twice. And the reason they were astonished was because of something that the government introduced in the court case. They said that the alternatives to HS2 would be set out in an annex we don't have yet, but an annex to the next environmental statement. Not the draft one that we're all commenting on, but the next one. And this would happen prior to the second reading of the hybrid bill. Now, this is being done, I suspect, in order to enhance the position in respect to the EIA. However, we argue that for an SEA, you have to do an SEA at a formative stage. You have to do an SEA at the beginning. So the idea that you can come in almost at the end and say, well, here's a little pack of alternatives, would everybody please like to now comment on them, that's 3 years too late. So we say it's not an option. Now, what was important in court was we also talked about the remedy. If we were to win, what was it we wanted to win? And what we said, just like on the compensation, we want to overturn, or the word that is used is quashed, we want to overturn the 2012 decision. And that was discussed to quite an extent in the court case. The other point worth making is that in respect of Europe, the judges could decide to refer this case to Europe. What is perhaps relevant in that area was there was quite considerable discussion about the legal precedents for this case. And all sides, the judges, the government side and our side, all agreed that actually the precedents are pretty thin. So it was quite an unusual situation. So they will be making law if they decide at this stage, or they may decide to go and ask Europe what their view is, before coming back and making a formal decision. Just a point I was asked to mention on the hybrid bill, and this just summarises the process. In late this year, we expect a hybrid bill laid before Parliament. Spring next year, we now know we expect a new consultation on the final environmental statement, not the one we're looking at now. Instead of being 5,000 pages, I'm assured it's going to be 55,000 pages. So it's a very early draft we've got now. Then in 2014, there will be this second reading, and that's what's going to establish the principle of the bill. Then, importantly, this select committee, or a select committee, gets set up. And to that select committee, we can petition. The public are entitled to petition those who are specifically and directly affected, is what the wording says. You can't, however, petition on the principles. You can only petition on specific aspects, which are local aspects usually. And you can only do it personally or via parliamentary agents. So it's getting out the checkbooks again time. Then there is a committee stage at which it goes through clause by clause, and then there's a report stage in which it goes back to the whole House, and then after May, so after the election, we are expecting then it will be the final third reading, and if it's got that far, it would then be passed. And the reason why we say after May is because the wording in one of the government documents says it is highly unlikely it would be passed before, so I take that it won't be. So that's just an update on the judicial reviews and the hybrid bill.